Well, hello everyone, and welcome to this live stream session. Thank you so much for joining me once again. My name is Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and you're here with me right now to talk about employment law, to talk about workplace rights, to get your questions answered. Most importantly, that's what I'm here to do. Here every Wednesday at this time to do just that. So again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. You can find us, I should say, across Ontario, BC, and Alberta. If you have an employment issue, we're the folks to talk to. We want to help. We've been helping hundreds of people just over the past few weeks, thousands of people this year, many, many more every year. So don't be bashful. If you have an employment law issue, you can start right now with the question. There are rights if you lost your job. There are rights if you're mistreated by your boss. There are rights if your job is changing. There are rights if your business is sold. I think you get it. You have rights. Unfortunately, not enough people know what those rights are. Well, we're changing that. I'm changing that. And I'm starting right now by answering your questions. If you have a workplace question, an issue, a dilemma, ask it, type it in right now. I'll see it. I'll read it. And you can walk away with all the knowledge you need. Don't be bashful. There's no bad questions, only answers today and solutions. So before we get started answering questions, let me give you some other contact information. I'm here for about 30 minutes. If you want to connect with me off social media, you want to have a private discussion or a private email exchange, so easy to do. All you have to do is go to employmentlawyer.ca. See that on the screen right here, employmentlawyer.ca. And when you go there, all the contact information is right there for you. Phone number, email address, everything you need right there, easy to use. So take advantage of that. I want to talk to you. We may not be able to have a lengthy discussion right now, but we can certainly do that privately. So that's what employmentlawyer.ca is for. And of course, you can read much more about your rights there. But that's later. Right now, I'm live with you here, as I always am, at your service, answering questions. I see the first question came in. I'm going to answer it right now. So please, as you're listening to me, as you're learning about employment law, ask your question as well. Again, I'm Lior Samfiru, the employment lawyer, and I want to start answering questions. So let's get to it. All right, first question today, the Eager Beaver, and that's from Filipino TV. I have recently been rejected from a new position because of a previous conviction that I received a pardon for. Because potential employers are asking me more detailed questions about my past, I'm not being hired. Is it discrimination? Is there anything that I can do? So it is illegal. Okay, it's illegal to not hire you, to fire you, or to treat you differently because of a conviction for which you've received a pardon. If you've received a pardon, that fact that you were convicted cannot form a consideration for your employer in terms of hiring, firing, etc. It's illegal. That would be a human rights violation. Can't do that. All right. So that also means that if you were to be interviewed and you're asked that question, you don't really have to be that honest about it. Listen, honesty is always good, but you really can't be punished if you're not honest. So something to think about. If you believe that you've been mistreated because of your record of offenses, we call that, because of the fact that you had a conviction, but that conviction was gone, you received a pardon for it, let's talk about it. That could be a human rights violation. You can take legal action against the company. And happy to help you. Not legal, just like it's not legal to let you go because of your age or your race or ethnicity. That's one of the grounds that's protected under human rights legislation. Okay, so if you want to connect with me, Filipino TV, easy to do. Just go to employmentlawyer.ca. Again, employmentlawyer.ca, and I'll be happy to connect with you and help you. Fantastic. Good question. Way to start off this session. You see how easy it is. You can do the same thing. If you've just joined us and wondering what is this thing all about, welcome. I'm Lior Samfiru, the employment lawyer, and this is my live employment law session. This is where you get to ask me questions, pick my brain with respect to anything to do with employment law and workplace rights, and I can give you the answers. I can give you the solutions. I can tell you what you need to know. So don't be afraid to get that started. Don't be afraid to push me and get me to put me to work. I want to be busy. I'd like to have 1,000 questions so I can get to all of them. If you ask a question, I promise I'll get to it. All right, let's continue answering questions, shall we? Reddit, from Reddit, our next question from Beetlejuice or Betelgeuse. Sorry if I mispronounced it. My employment contract says that if I forget to clock out at the end of my shift, I will only be paid for 4 hours and not the full shift. Is this legal? Can my employer dock my pay if I forget to clock out? Why? Oh my God, why would they do that? No, of course that's not legal. For an employer to do that is ridiculous. It's outrageous. No, if you work, you have to get paid, full stop. It can't get any simpler than that. Your employer cannot dock your pay. They cannot punish you because you didn't clock out by not paying you for what you've worked. It's ridiculous. What if they said, well, tell you what, employee, if you don't clock out, you have to pay us? It doesn't work that way. No. So this is completely and totally and utterly illegal. All right. So here's what I want you to do. You have two options. An email from me to your employer is going to change that in 30 seconds. Okay. As soon as I get back to them and I say that's illegal, see how fast they back off immediately. The second thing, you can also file a complaint with the Ministry of Labor. That's not legal. Okay. So remember, if you've worked, you have to get paid. Nothing else matters. If your employer doesn't do that, if they find reasons not to pay you for the time that you've worked, there's going to be consequences. You want to reach out to me. And of course, you could do that through employmentlawyer.ca. Again, employmentlawyer.ca. I got to say, I don't know that I've actually heard the scenario before. I absolutely believe it. Completely illegal. Why would an employer ever think it can do that? Thank you for that question. And I'm Lior Samfiru, the employment lawyer. As you've seen, I'm here answering your employment law questions live. If you're in Ontario, British Columbia, or Alberta, I got you. Okay, let's get some answers going on right now. Let me point you in the right direction. Let's make sure that you know what the law says. All right, right now I'm live, so ask your question. Next question comes from Glad to See. Well, I'm glad to see you too. Employer wants to change our contracts and move everyone's shifts around. How much are they allowed to change everything on us? Fantastic question. Really good question. So an employer is not allowed to make significant changes to the terms of employment. I'll talk about significant in a second. If an employer makes significant changes, that gives the employee the right to consider their employment as being terminated and force the company to pay them severance. Now, you cannot physically restrain, you cannot physically stop your employer from doing that. There's no employment law police that comes in and arrests your employer if they do that. But what you can do is, if you're not okay with what your employer is doing, is you can consider that as a termination, call this constructive dismissal, and force the company to pay you severance. Now, significant changes. What's significant does depend on every scenario. If I give you an example, if you used to work 9 to 5 and now they wanted you to work 8:30 to 4:30, that's not going to be considered significant enough, and it's probably something the company can get away with. On the other hand, if you used to work 9 to 5, now it's going to be 12 to 8, yeah, that's a significant change. That would be a constructive dismissal. So I need to know more about what your employer is doing. Now, they may be doing a few small things, but together it adds up to something significant. That can easily be constructive dismissal. So glad to see the devil's in the details. Let's talk about it. Here's something I want you to keep in mind. If you kind of don't do anything about it, they implement these changes, you continue working, and then down the road you change your mind, it's too late. If you continue working, you're considered to have accepted these changes, and then you're stuck. And by accepting these changes, you're giving the company the right to do it again in the future. So it's a huge problem to just do nothing and accept these changes. If you want to talk about constructive dismissal, let's connect off social media. You can easily do that through employmentlawyer.ca. You see that address there, employmentlawyer.ca. Fantastic question. Glad to see. I'm glad you asked it, because there's other people that deal with these types of situations, so they need to know as well. And you know what to do now and how to reach me. Follow-up questions, by the way, ask them. Don't be afraid. All right, guys, I'm Lior Samfiru, the employment lawyer, and I'm going to continue answering your employment law questions that have just come in. Ask them as well. If you ask now, you're guaranteed to get an answer before the session is done. Don't wait till the last minute. Jesse has our next question. Thanks, Jesse. I'm not salaried employee and only get paid by the hour that I have worked. I was given 3 months notice, but continue to work during that notice period. Am I eligible for severance? Well, Jesse, I need to know how long you've worked there. I need to know your age, and I need to know the type of job that you're doing. So that allows me to assess your severance. Now, the 3 months notice that you got counts towards your severance, but you could be owed 12 months severance. And if you got 3 months notice, the 3 months counts towards that. So you need to tell me, Jesse, your age, your position, and the length of your employment. Without that information, I have no way of knowing how much severance you're owed. I don't know you, so I have to know your age, your position, and the length of your employment. So type that in, and I can tell you what you're owed. Thank you for that question, and type in that follow-up information, Jesse. See, Anita has our next question. My employer has gone silent now that I am about to return from parental leave. What do I do if they just don't message me back? Well, if they ghost you, and if they don't make arrangements to bring you back, that could be a breach of several statutes, employment standards, human rights. It's illegal. They have to bring you back to the same job, same position. So depending on when your return date is, it may not be imperative that they get back to you right away. For example, if you're not coming back, until July, right now we're in April, then they may say, okay, we'll kind of make arrangements as it gets closer. But if you're scheduled to come back next week and they're ghosting you, one thing you may want to say to them is, hey, I'm going to be there Monday to start working. See how fast they respond then. If they still don't respond, let me have a crack at it, because that's illegal, all right? They're clearly hoping you'd go away. They can't do that. Have to bring you back, same job, same pay, same everything. And man, oh man, is the law going to come down hard on them if they don't do that? So try what I said, Anita. If you need my help, glad to help you. Got your back, and you can reach me through employmentlawyer.ca. Again, employmentlawyer.ca, the place to go to reach me, right there on the screen. Phone number, email, everything you need is right there. All right, thank you for that. Again, follow-up questions, guys. Jesse, you still there? Ask that or give me that information. Let's make sure we get some answers. If you've just joined us, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and I'm here to help you. All right, so let's make sure we get you some answers. So Jesse just gave me the answer here. Jesse says, worked for 2 years, 45. Okay, so in your situation, you're likely to be owed right around 4 to 5 months of severance, 4 to 5 months. The 3 months notice counts toward that, but there's additional amounts owed to you. I would also want to read your employment agreement myself. So if you'd like a consultation, Jesse, let's connect. You can reach me through employmentlawyer.ca. Again, employmentlawyer.ca. This raises a very good point here. If you want to know how much severance you're owed, maybe you lost your job like Jesse, and you want to understand what is severance. Is my offer correct? Is it not correct? Am I owed more? Am I not? How do you do that? Well, you can always call me and ask me. Or there's even a simpler way. You can grab your phone and use our severance calculator. You go to pocketemploymentlawyer.ca. That address is right there, pocketemploymentlawyer.ca, and you click on the severance calculator. Ta-da, you're right there. The severance calculator is designed to give you an estimate, an assessment of how much severance you're owed. Completely free. It's completely anonymous. You could try to pay for it, then you would fail. There's no way to pay for it, okay? You answer a few questions and you hit the button, and it's going to calculate how much severance you should be getting. Maybe it's 6 months, maybe it's 10 or 12 or 24. It's right there for you. It should always be the very first place you go to if you lost your job. It's also a great tool to have just if you're curious or you're worried about losing your job. A lot of people these days are worried about losing their job with tariffs and everything happening south of the border. So if you want to know what severance would look like for you, then you should want to know that. Go to pocketemploymentlawyer.ca, use the severance calculator, and you'll be shocked and surprised by just how much severance you're owed. Check it out. Again, free and anonymous. All right, but right now I'm continuing to answer questions. Ask yours. You still have so much time to answer questions. Don't be bashful. Let's get some questions answered. Next question comes from YouTube from Below Fine. Is there anything you can do if a company's hiring practices seem to be in bad faith? I was hired for a position that would eventually require some licensing, but they would hire and pay an unlicensed rate. After I quit my job and was approaching my start date, they told me I couldn't start without my license and granted me special privileges to study and take the exam. When I complained about the changes and what my contract stated, they fired me for insubordination. That is bad faith. And potentially, not only could you get severance, you could also get additional compensation for the income that you lost with the other job. The company can't change terms on you. So they can't hire you on certain basis and then change their mind because you rely on that. So I was hired on this basis. That's why I quit my other job. Now you're saying that's no longer the case. I'm relying on that. So there are going to be consequences to that. It's not just your severance. If you had another job and you quit it and it's going to take you 6 months or 12 months to replace that job, your employer, the new company, may have to pay for that. We call this wrongful hiring. You've heard of wrongful dismissal. There's also such a thing as wrongful hiring. So let's connect if you want below fine so we can talk specifically about your situation. I want to understand more about this license issue. And you can connect with me through employmentlawyer.ca. Again, employmentlawyer.ca. Very interesting questions today so far, guys. Keep them coming. I see another one came in. I'm going to answer it right now. But if you're watching and you haven't asked a question, come on. What are you waiting for? Get that question asked. Give me the chance to help you. All right, next question from BD. Maybe I'm mispronouncing. My husband works in construction as a site supervisor. He's recently had some health issues and needs to do more desk work, and his employer refused this. He can't do the same physical tasks or all the travel or all the travel. So no, your employer or his employer cannot refuse this. There's an obligation to accommodate. We call this the duty to accommodate. And that means that if your husband can get a doctor's note saying this person needs modified duties, he needs to be sitting at a desk at least for a while, your employer has to, or the employer has to accommodate that. If it's at all possible to do it, they have to do it. They can't say no. They can't say we don't want to. They can't say other people are going to want the same thing. None of that matters. That obligation to accommodate is one of the most important obligations that an employer has. One of the most fundamental obligations. It starts with the doctor's note. It's not enough for your husband to say, hey, I need to sit at a desk. That needs to come from a doctor. Once you have that from a doctor, you give it to the company, they have to accommodate. If they don't, if they refuse, that's a human rights violation. You have to call me at that point. I can get them to accommodate, or I can get your husband out of there with compensation. Either way, there's remedies available. Start with the doctor's note. And if anything bad happens, if they don't want to, if they refuse, if they are taking too long, let me know and I'll help. So now you know, BD, to connect with me. You know the address, employmentlawyer.ca. That's how you find me. And I'll be more than happy to connect with you and your husband and provide help if needed. But hopefully you don't need it. Hopefully the employer does the legal thing, the right thing. A lot of people ask me about that, the duty to accommodate. You may need modified duties, modified hours. Maybe you need, for medical reasons, to work from home instead of from the office. Well, if there's a legitimate medical reason backed up by your doctor, then your employer has to give it to you. It's not up to them. And by the way, your employer doesn't get to question your doctor, to say, I don't believe your doctor, or to say, I want another second opinion. None of that is possible, okay? So your doctor has the power. Use the doctor if you need it. And if there's any problems, I'm here. You know what to do. Just reach out to me through employmentlawyer.ca. All right, questions. I love questions. So ask yours too. More have come in. Let's get to answering some more questions. Frosty on Reddit has a question. If I sign a mutual separation agreement from my employer, am I still entitled to receive EI? The software company I work for is planning to restructure my role in the department, and I have asked to be packaged out, but the offer is only for 3 months. I am 6-year employee. So forget about EI right now, okay? You're owed much more than 3 months, okay? let's see, you didn't give me your age, but I know you've been there for 6 years. You could be owed 6 months, 8 months, even 12 months of severance, depending on your age and your job. So right off the bat, I can tell you 3 months is not enough. But can you also get EI once the severance runs out? Sure, of course you can. The issue is you cannot, should not, no matter what, sign the severance offer, this agreement, without speaking to me. Do you know how many times people contact me, they're let go, and they say, well, I don't think my employer's calculated my outstanding vacation pay correctly. Can you help me? And I look at it, and I'm saying, yeah, you're right. You're owed some vacation pay. You probably owed another couple $100 in vacation pay, but you're actually owed $50,000 in severance. People often ask me, well, I'm concerned my employer didn't complete the record of employment correctly. And I look at that, and I'm like, you're right. But the bigger issue is that you're owed another year's pay. So when you lose your job, the big issue you need to be concerned about always is the severance. Everything else is kind of secondary. Not saying it's not important. Not saying it's not going to get resolved. But the issue is severance. Too many times people assume their severance is fine. No, it's not fine. In 90% of cases, it's not even close to being fine. Okay, that's why you need to reach out to me. If you don't like me for whatever reason, no problem. Reach out to another employment lawyer. That's okay. But do the right thing, the smart thing, the only thing. Get some advice if you lost your job, always. All right, let's see. Next question comes from Harold. By the way, before I take Harold's question, if you just joined us for the last 10 minutes or so, welcome. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, answering questions live about workplace rights. So if you've just joined me right now, you still have time to ask your question. If you want to know about your boss, what they're doing, about your job, your severance, your mistreatment in the workplace, ask the question. Completely easy to do, easy and free and helpful. So ask that. But as I said, Harold has our next question. I've been working as a contractor for a local plant for the last 11 years. There's been concerns over a decrease in workload. If my contract is cut, what sort of options do I have? Well, I have news for you, Harold. You're not a contractor. You're actually an employee. If you've been working in a plant for 11 years, doesn't matter what the company says, doesn't matter what you've signed, you are an employee. And the law considers you an employee. If you look like an employee and act like an employee, you can figure out that, yeah, you're an employee. So what does that mean? That means if as a result of cuts you lose your job, you're owed severance. Now, I don't know the job you were doing or your age, but you could easily be owed a year's pay, 12 months, maybe more. So what do you do as soon as you lose your job? If that happens, hope it doesn't. But if it does, call me. Okay, reach out to me or email me. Let's have that discussion. I'll help you get that severance. You can easily reach me through employmentlawyer.ca. By the way, it's a very, very common thing when individuals are misclassified. They're called contractors, but they're really employees. Who's a contractor? A contractor is someone that's in business for himself or herself. So if you run a business and you have a bunch of clients that you go to, then you're a business person, you're a contractor. On the other hand, if you work for one company, you've been doing this for a long time, and you go to work, you do your job, you come home, you're an employee. It doesn't matter what you signed, how you pay your taxes, what the company you work for says. None of that matters. You're an employee. So Harold, hopefully that makes sense. If you have any follow-up questions, ask them. I'm still here. Okay, let's see. Next question is from Prisma TikToks. I'm being ignored on a return to work after a disability medical leave. Is this discrimination? What should I do? It's been 2 months since I wanted to return to work. So if you have a doctor's note saying you're ready to return and your employer won't let you, ignoring you won't let you, that's number one, it's a dismissal. It's a wrongful dismissal. You're now owed severance. But it can also be a human rights complaint. So if you want to go back to work, guess what? If I send them a note, see how quickly things change, how quickly they respond and take you back. So that's one option. I can send them a note and all of a sudden, oh yeah, big misunderstanding. Sorry for not getting back to you. Back to work you go. Or you can now already potentially, if your employer's been ignoring you for 2 months, man, that ship has sailed. You can already consider yourself as being terminated and potentially a human rights violation. So we can pursue that avenue if you want. If you want to go to work, I can help you. If you say, forget about that, I just want compensation, I can help you with that as well. Either way, got your back, Prisma. So you know what to do. You can reach me through employmentlawyer.ca. Again, the employmentlawyer.ca. Harold had a follow-up. Says, so despite signing annual contracts, we're employees. Does this mean we're owed standard vacation pay and the likes, like full employees would receive? Absolutely. The fact that you sign a contract every year means nothing. Doesn't change that at all. So yes, you're owed vacation pay, holiday pay, overtime pay, all of that you're owed because you are an employee. Completely illegal what your employer is doing. Not uncommon, unfortunately, but completely and totally illegal. All right, so you know what to do. I'm right here if you need some help, employmentlawyer.ca. All right, let's see if we can get one or two more questions answered. You can kind of squeeze in a question under the wire here. Next question comes from Pixel LT. I've been let go after 12 years of employment. I'm at 45 years old. I've signed the release form. I've been told that the final payment will be delayed. Sorry, let me see here. What is the normal time frame for the final payment? What are the final steps to conclude a relationship in a professional matter? So first of all, I wish you wouldn't have signed this release. I don't know obviously anything about your situation, but unless you were represented by a lawyer or at least consulted with a lawyer, I can almost guarantee you that whatever you agreed to is bad. All right. Now, in terms of when the payment is due and how much flexibility they have, I'd have to see it, right? I'd have to see that agreement. I can't tell you without actually seeing it. But here's the thing. If in fact they're in breach of the agreement, let's say they were supposed to make a payment and they didn't make that payment, that potentially could allow you to get out of that so you can get your full severance. So I'll give you an example. Maybe you're owed a year's pay and you agreed to 7 months. Well, potentially that's a very bad deal, but because they haven't lived up to it, maybe we can get you out of that agreement so you can get 12 months. So either way, for me to give you advice about your rights and whether or not they've done something wrong and what kind of flexibility and what your options are, I need to see that agreement. So to connect with me, reach out to me through employmentlawyer.ca. Again, employmentlawyer.ca. All right, let's take one last question with me, Lior Samfiru, the employment lawyer. This is from Fastar888. Can your insurer terminate your benefits if you can only return to work from LTD part-time for the remainder of your career? Are your benefits still guaranteed if you make less than the commensurate amount in any occupation? Yes, you should still be getting your benefits and they should not cut you off. That doesn't mean that they won't try. The good news is we have a whole team at the office dealing exclusively with disability benefits and disability insurer. Connect with me. I'll hook you up with one of my partners so you can discuss this and talk about the options and what's legal and what's not legal. So Fastar888, you got to reach out to me through employmentlawyer.ca. All right, I think I'm caught up here. What a great session today. Lots of questions. I'm glad I had the opportunity to speak to you and help you. And I'm Lior Samfiru, the employment lawyer, wanting to always get as many questions answered as possible. Thank you for joining me today. I'll be back next week. My colleagues will be back Thursday at 1 o'clock. My colleague Haley Auger will be back at 1 p.m. Mountain Standard Time right here. But don't wait for that. Don't wait for me to be back next week. If you want to connect with us now, just go to employmentlawyer.ca. Don't wait until then to find out about your rights. You can find out about your rights right now. I'm Lior Samfiru with Samfiru Tumarkin LLP. Thank you so much for joining me. We'll talk again soon, guys. Take care.